So if you've got a job in California, chances are you've signed a non-solicitation agreement, right? They're tucked into almost every employment contract out there. But what if I told you that whole section, the one stopping you from contacting old clients, might be totally useless? Let's dig into what that actually means for you and your career.
You know the scene. You just landed a great new job, you're excited, you're ready to go. But first, the paperwork. And buried in that stack of documents is this really dense paragraph, just full of legalese, about who you can and can't talk to if you ever decide to leave.
I'm willing to bet a lot of you are nodding your heads right now. It's a non-solicitation agreement, and it's pretty much standard practice here in California. So when you sign that, what are you actually agreeing to?
Okay, so from the employer's point of view, this makes a ton of sense. I mean, they've poured time and money into training you, into building up that client list, so naturally they want to protect that investment. They don't want you to just walk out the door and take all their customers with you to a new gig. It's all about protecting their business.
But, and this is a big but, here's where it gets super interesting. Even though these agreements are everywhere, California has this really strong, specific public policy about your right to work. So what a company wants to put in a contract and what the law actually allows them to enforce, well, those can be two very, very different things.
And that's the million-dollar question, isn't it? You signed on the dotted line, you agreed to it. So if you leave that job and give one of your old clients a call, can your old boss actually sue you?
And here it is, the big reveal. The answer, in the vast majority of cases in California, is no. These agreements are generally void and completely unenforceable. I know, it's a huge surprise for a lot of people who sign these things without even thinking about it. So why do companies still use them? Honestly, a lot of the time it's just a scare tactic. They're banking on the fact that you don't know your rights.
So why is this the rule? Well, this isn't some random court decision. It's baked right into California state law, a law that is very, very serious about protecting employee mobility and your right to earn a living in whatever field you choose.
And the law itself is incredibly direct. This isn't buried in some obscure legal theory. It's right there in black and white in the Business and Professions Code. It says that any contract that restrains you from doing your job is, and I quote, to that extent, void. That is an incredibly powerful statement.
So the bottom line is that California courts look at these agreements and see an illegal restraint of trade. If a contract is trying to stop you from working in your field, or it's just way too broad, the law says it's no good. And that means you can generally and lawfully contact your former employer's clients without worrying about getting sued.
Now hold on. Before you run off and start cold calling your entire old client list, you need to know that while this general rule is incredibly strong, it's not absolute. The law does have a few very specific, and I mean very narrow exceptions.
And these are basically the big three. First, you can't use your old company's protected trade secrets. That's not just competition, that's a form of theft. Second, the rules are different if you're selling an entire business, because you're also selling its goodwill. And the same idea applies when a partnership breaks up. For the average employee, though, you should know that the courts interpret these exceptions really, really narrowly.
This gets us to how courts actually think about these things. It's like a balancing act. On one side, they weigh how much this agreement harms an employee's ability to actually work and make a living. On the other side, they look at whether the company needs this to protect itself from genuinely unfair competition. And unfair is the key word there. The goal isn't to stop competition altogether, it's to stop things like stealing trade secrets in very specific situations.
Okay, so let's bring this all back to the real world. What does this mean for you right now? Let's say you're starting a new job tomorrow, and this kind of document lands on your desk. What should you do? Here's a quick, practical checklist to keep in your back pocket.
First off, just read it. Know what you're signing, even if it's probably not enforceable. Pay attention to how broad it is and how long they say it lasts. Number 3, always keep a copy for yourself. And most importantly, number 4, if you have any real concerns, talk to an employment law attorney. They're the ones who can give you advice tailored to your exact situation.
So, we'll leave you with this question to think about. Knowing that California law is so heavily on the side of your right to work, does that change how you look at your employment contract? It's a really crucial piece of knowledge for any professional trying to build a career here in the Golden State.